No grounds to slash salary. SC restores compensation for road accident victims. FAMI Lyth Supreme Court has taken an exception to the reduction of salary of a deceased in computing compensation under the motor vehicle in a road accident case, while also emphasizing even the children and the parents are entitled to compensation for loss of consortium. A bench of Justices Sudhanshu Dhulia and K. Vinod Chandran restored the order of the Motor Accident Claim Tribunal, which awarded a total amount of Rs. 23,07,000 to the dependents, adopting the salary claimed of 10,000 rupees and reducing 13 Rd for personal expenses, while taking 34th of 40% of the income of the deceased as future prospects. The appellants, Hansa Devi and others, were the legal representatives of the deceased in a motor accident. They were the widow, 3 minor children and parents. The deceased was the driver of a truck in which a helper cleaner was accompanying him. The driver had alighted after parking the truck, and when he was boarding the truck, another truck driven rashly and negligently hit him and he died on the spot. An FIR in the matter was lodged. The claimants sought compensation for the death of the breadwinner of the family, who was 28 years old when he met with the accident and succumbed. The tribunal awarded a total amount of Rs 23,07,000. The wife was granted loss of consortium at the rate of 40,000 rupees, the children 25,000 rupees each and the parents 10,000 rupees each. The funeral expenses and loss of estate was also awarded at the rate of 15,000 rupees each. The insurance company filed an appeal before the High Court, in which there was considerable deduction made especially on the salary, which was reduced to 4,076 rupees, adopting the minimum wages for a driver as 5,434 rupees with 40 future prospects. The claimants were granted only 40,000 rupees towards loss of consortium. The amount awarded was reduced to Rs 1234,105. Having heard the parties, the bench said, "We find no reason to accede to the reduction of income as done by the High Court." The court noted the accident occurred on May 8, 2014. In Ramchandrappa vs Royal Sundaram Alliance Insurance Co. Ltd 2011, this court held that even a coolie would get an income of 4,500 rupees in the year 2004. Hence, an unskilled laborer, considering the marginal and incremental increase in each successive year at the rate of 500 rupees per year, would be entitled to get almost 10,000 rupees in the year 2014, it said. Thus, the bench said, the claim made before the tribunal with respect to the driver of heavy vehicle getting 10,000 rupees as wages per month must be necessarily accepted. Insofar as the loss of consortium, the court pointed out, it has been held in New India Assurance Company vs Somwati and Ors 2020, that even the children and the parents are entitled to compensation for loss of consortium. Since no appeal is filed by the claimants from the award of the tribunal, we do not think there is any enhancement required. Still, the award made as compensation for loss of consortium to the children and the parents by the tribunal has to be retained, the bench said. Swipe left for next video. Therefore, the court set aside the order of the High Court restoring the order of the tribunal. The amounts, with interest, as awarded by the tribunal would be dispersed to the claimants within a period of 2 months, which would be equally apportioned in the name of the wife, children, and parents. It clarified. If any of the minor children have not attained majority, the amount shall be kept in a fixed deposit, the interest of which can be dispersed to the mother who is the guardian. The bench further added. Latest blogs.